To finish off secure transactions, we look at creditor and debtor rights under the UCC. Now, we know that debtors and creditors have rights under the UCC, and the UCC is also going to impose rights and duties on debtors and creditors. The security agreement itself is going to govern most of the rights and duties applicable to the parties. And so after today's lecture, you should be able to examine, in which we're going to examine the rights, duties, and remedies of the parties to a secured transaction. You should be able to answer the following questions. What rights do secured creditors have under the UCC? And what rights do debtors have under the UCC? And finally, what are the remedies available to a secured creditor after the debtor's default? So debtors and creditors have rights under the UCC. The UCC imposes rights on debtors and creditors. And the security agreement is going to govern most of the rights and duties that are applicable to the parties. So in the agreement itself, in that agreement, the rights and duties of the parties are going to be set out. If the security agreement is silent on a particular issue, the UCC will supply the proper rule. So let's first of all talk about the rights of secured creditors. Secured creditors have rights under the UCC. One of their rights is an information request. A party who's considering taking a security interest is entitled by the UCC to obtain a certificate from the relevant filing office that identifies all perfected financing statements on file for that debtor. A secured party may, at its discretion, ask for an assignment and release. Therefore, they have the right to assign any part or all of a security interest to another party, or release part or all of that security interest, the collateral covered by that security interest. In that case, the party is entitled to transfer its rights under the agreement. A secure creditor also has the ability to amend a financial statement. A filed financing statement may be amended. Now, the amendment, however, must be agreed to and signed by both the debtor and the secured party. So a secured creditor has those rights under the UCC. Now, debtors also have rights under the UCC, and these again are in addition to whatever the security agreement provides. UCC debtors have rights. UCC debtors who have given a legal interest in specific assets have these rights. So the first of all is an accounting. A debtor can request that the secured creditor confirm the debt remaining or the collateral covering the remainder of the debt. How much is owed or how much of the collateral extends to the remainder of the debt. A debtor also has a right to have a termination statement filed. When a secured debt is fully paid, the secured party has to send a termination statement to the debtor and file a copy with the appropriate filing office. This is in order to free that collateral up from any cloud on its title. And if a debtor requests the filing of a termination statement, if a debtor requests that, the creditor only has 20 days in which to respond to that request. Now, Article 9 governs remedies of the secured party when the debtor defaults. So on the debtor's default. And of these, the first we want to look at is repossession. A creditor may be entitled to repossession. The right to go get the collateral and take possession of it again. Now, no judicial intervention is necessary for repossession. We don't have to go to court and get a court order permitting the repossession. A creditor is generally entitled to it unless the secured party states otherwise. Now, default, when we talk about default, the default is the failure to pay the debt when due, as required by the security agreement. So the law provides creditors also with a right of self-help, and self-help means following the debtor's default, the secured party can repossess its collateral and either retain it for satisfaction of the debt or resell it and apply the sale proceeds to the outstanding debt. Now, a party that wants to exercise its right to self-help must do so without a breach of the peace. And we don't know exactly what breach of the peace refers to. But in general, we look to see, is there a tort or a crime involved? If there is, then it's probably a breach of the peace. You have a right to go take a person's vehicle. If it's sitting in their driveway, you know where it is, you've got a right to repossession, you go take it. However, you can't go assault someone and then take the vehicle and run away because you have breached the peace. There are additional secured creditor remedies. Creditors have remedies other than self-help, and the most common one, of course, is a judicial remedy. Creditors can pursue a judicial remedy, which means the creditor can sue the debtor, obtain a judgment against the debtor, record the judgment in the appropriate filing office, and finally obtain a writ of execution. This is when you're going to have to go back to the court and ask the court to execute a writ of execution, which then orders the sheriff to have the collateral seized. So you won't have the sheriff go out and seize the collateral. Now that's a very complicated form of remedy, but it's certainly available for a creditor. Unsecured creditors cannot repossess or foreclose on property without going through this process. Secured creditors can avoid this process. Unsecured creditors cannot go take property without getting the judgment first. Foreclosure by sale is another creditor remedy, meaning the secured party can choose to sell the collateral. So secured party can sell the collateral and take that and apply the amount to the debt. However, if the secured party is selling the collateral, whatever secured party chooses to do that, it must do so in a commercially reasonable manner, meaning in good faith as a commercially reasonable entity would. And they must also notify the debtor of the time and place of a public sale or the time after which a private sale will occur. Now, if a secured creditor elects to sell its collateral following the debtor's default, the creditor must then, in the following order, pay all reasonable expenses stemming from retaking, holding, or preparing the collateral for sale, satisfy the balance due. So you pay your expenses, you pay the amount that's due, and if there are any other secured creditors who have an interest in that same collateral, they get what's left over. And if there's anything left over that after that, they turn over that surplus to the debtor. Now, this rarely happens. What you should take away from this, however, is the idea that this is a winner-take-all type situation in which the secured party who takes the collateral, repossesses it, sells it, gets to have its entire debt paid before it has to turn over anything to other secured creditors or to the debtor. Now, if the debt remains unsatisfied after the collateral has been sold, meaning there wasn't enough money that came out of the sale to pay off the balance due, the secured party can then sue the creditor to obtain a deficiency judgment. And a deficiency judgment is the amount that is remaining after the retained collateral has sold. So anything left over of the outstanding debt I can collect by seeking a deficiency judgment. Strict foreclosure occurs when a secured creditor retains repossessed collateral. A secured party who keeps the collateral in satisfaction of the debt cannot seek a deficiency judgment. If you choose to take the collateral and retain it for your own use, then you cannot seek a deficiency judgment. Redemption is actually a right given to the debtor. The debtor has a right to what we call redeem the collateral. And redeem the collateral means to get its interest back. The debtor has a right to take the collateral back. It can only do so, however, by tendering performance of all obligations secured by the collateral, all the money that has been owed against the collateral. And furthermore, they must pay any expenses that were incurred in the retaking, maintaining, or sale of the collateral. So redemption is a very powerful remedy available to a debtor, but it often is not taken advantage of because it's simply too difficult to pay. The debtor doesn't have the money to pay for the debt originally, so is unlikely to get it after the collateral has been seized. So in conclusion, what did we learn today? Secured creditors have rights under the UCC. Debtors have rights under the UCC, and Article 9 governs remedies of the secured party on the debtor's default. That's it. Thanks for listening.